Honorable Superior Court for the Judicial District, Antonio Milford, advocate for the transaction of criminal business, now open session in this place. All persons having cause, action pending, summoned, found to appear herein shall take due notice thereof and give their attention according to the law. Now the Judge H. Gordon Hall presiding. Good morning, Your Honor.
Good morning, Marshal. Good morning, everyone. Please be seated. So, we have things this morning before the jury?
Yes. Your Honor, before the rebuttal case by the state starts, procedurally, I do want to make, as is required by the practice book under 42-40, to renew the motion for judgment of acquittal, that even in a light most favorable to the state and the evidence that the state presented, that the prima facie case has not been created and presented to this court. At this time, the jury has now heard evidence of the defense of others' defense and the justification defense. So that is now been presented. I rely on the this motion, but the practice book does require renewal of the motion at this time, and I'd ask the court to grant that motion.
Thank you, Mr. Riccio. Mr. Devlin?
I would just say, I think it's a question of fact for the jury. If the jury chose to credit certain evidence that's been presented in this trial, it would support a conviction. Thank you.
All right. I have had the opportunity, of course, to hear the testimony and view the evidence as both of you have, and as the jury has. And I do find that if the jury were to credit the witnesses that they've heard, or certain of the witnesses they've heard, as well as the supported by the exhibits, and taken in the light most favorable to the state, the jury could find that each of the elements of the crime charged has been established beyond a reasonable doubt. So I will deny the motion. And do we have anything else?
No, Your Honor.
We're ready to proceed, Your Honor.
Okay. Can we bring the jury?
Yes, sir.
Did the clerk give you guys the papers that? Okay.
Yes, Your Honor.
Good morning.
Good morning.
Mr. Devlin, the defendant Mr. Slitt, the defense rested yesterday. Does the state have a rebuttal case?
Yes, Your Honor, the state does have a rebuttal case and has one witness to call, and that would be Dr. Darren Portrait.
You may call the witness.
And you come back to space, sir, please.
If you switch your right hand, you solemnly swear or solemnly sincerely affirm that the case may be, that the evidence you should give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
If you state your first, last name for the record.
Darren Portrait,
If you please spell out your last name for the record.
Porcher.
If you state your business address for the record.
3222 Cambridge, that's spelled Cambridge. That's Avenue, number 2, Riverdale, New York. Zip is 10463.
Thank you, sir.
Please have a seat, sir, and pull up to the microphone so we can all hear you. You may inquire, Mr. Slitt.
Thank you. Good morning, sir. How are you?
Good morning, sir.
Could you tell us the jury your current occupation, please?
My current occupation is adjunct professor and expert witness.
And what field are you a professor in?
In criminal justice. I teach criminal justice as well as criminal law.
Could you trace for the jury your professional background?
Sure. My professional background consists of, I worked in the NYPD for 20 years. I was a police officer. I was a detective. I worked in internal affairs. I was a sergeant assigned to the NYPD's Police Academy, where I trained police recruits on firearms, tasers, use of force, and procedural guidelines in connection with
the state of New York, as well as on a federal level. I am a former Army officer. I had 4 years on active duty and 16 years as a reservist. And I have a bachelor's degree from St. Joseph's. I have a master's degree in MPA, a master's in public administration from Marist College. And I have a doctorate degree from Fordham University.
And what field of study is that in?
It's a concentration of, I want to say it's a collaboration of criminal justice and educational leadership.
You mentioned you were in the NYPD for how many years?
20 years.
And did you retire?
I retired in good standings, yes.
And you mentioned you were in the internal affairs unit there.
Yes.
Could you tell us what internal affairs is?
I worked in the Internal Affairs Bureau from two components. Initially, I worked there as a detective. Upon being promoted to sergeant, I went into the field as a patrol supervisor. Then I went to the police academy. And after leaving the police academy, I went to Harlem, where I was a lieutenant. And then I was transferred back into the Internal Affairs Bureau as a lieutenant. As a lieutenant in the Internal Affairs Bureau, I managed a team of police officers, detectives, and sergeants in connection with investigations into police misconduct. So as an investigator, I focused on the one component of strictly doing the investigations. However, as a lieutenant, I focused from the perspective of overseeing and managing these investigations into police corruption, police misconduct and police corruption, excuse me.
So that's generally what internal affairs consists of.
Yes.
And what leadership and supervisory experience did you have at the NYPD?
Well, as a sergeant, I trained thousands of recruits in the NYPD's police academy, and as well as a patrol supervisor in the city of New York, I supervised numerous police officers in my capacity as a patrol supervisor. As a lieutenant, I now became something we refer to as a platoon commander. And as a platoon commander, I was responsible for the day-to-day operations on a particular tour that I was scheduled on. And then as an integrity control officer, I was basically the person. The easiest way I can describe is what an integrity control officer does would be something like HR in private industry. And as in the military, I was an NCO. Well, I was an NCO, so I managed a series of soldiers and airmen, because initially I was in the Air Force and I went into the Army. And then as an officer in the Army, I was an executive officer, so I managed a series of soldiers, lieutenants, for a variation of different responsibilities. So.
And you said you had a role at the police academy at the NYPD?
Yes, at the police academy, I was a sergeant, and one of the things that I did was we have something we refer to as justification, whereas a police officer in the NYPD must pass a justification exam in order to be afforded a firearm to carry on patrol. So I provided the instruction as to what an officer can and can't do. We refer to it as shoot or don't shoot, as well as, and they had to pass that exam. In addition to that, I also taught use of force, the use of a taser, and a variation of different policies attributed to that of the NYPD.
And you mentioned you were a lieutenant. Is that the rank you retired at?
I retired at the rank of lieutenant.
And I assume you were trained in the use of firearms?
Yes, I was trained in the use of firearms. As a sergeant, I provided training for the use of firearms. But at the same token, throughout the course of the 20 years in the department, twice a year, I had to qualify with a firearm.
Were you an instructor at all the time?
I wasn't. What happens with firearms is we have a firearms section, but what I did, I instructed the recruits on what to do in terms of when you can shoot and when you can't shoot, and that refers to the justification component.
Are you trained in the use of tasers?
I am trained in the use of a taser, yes.
Were you at some point a taser instructor?
It wasn't so much as a taser instructor because we didn't have isolated instructors that taught tasers. However, that fell into the battery of instruction that I partook in as a sergeant in the NYPD.
Okay. I want to pivot a little bit to your work as a professor. Could you just tell the jury a few of the classes that you teach now?
I teach, I want to say practically everything in criminal justice. I teach criminal law. I teach crime and public policy. I teach policing. I teach criminal procedure. I teach terrorism. I teach ethics in criminal justice, ethics in policing, basically any and everything under the sun as it relates to policing. I've been a professor for 17 years.
And have you testified in court before?
Yes, I have.
Approximately how many times?
Within the last 4 years, it's been 3 times.
Okay, and I guess I'm just referring to in your capacity as a witness in these types of cases, and not as a witness.
That is correct.
Police officer. So let me talk to you about this particular case. Was there some point you were asked to consult on this case, the circumstances that occurred in West Haven on January 15, 2020?
Yes, I was.
And how did that come about?
Assistant Attorney General Devlin reached out to me and presented a series of facts and asked me if this was something I was interested in doing and was I capable of doing it. And I agreed, and that's what brought us to this point that we're at today.
So Inspector General Devlin hired you.
Yes, sir.
Okay. And did you will you send some materials with respect to this case, this investigation?
Yes, I was sent a battery of discovery information in connection with this case that I was fortunate to review.
And so that came from my office, essentially the Inspector General's office?
Yes, it came from the Inspector General's office.
Did you review the entire investigative file as far as you knew?
I reviewed the entire investigative file as it stood at that point in time.
So that included all the body-worn cameras of the officers involved?
Yes,
The motor vehicle cameras as well?
yes.
Are you aware of the defendant making statements at the scene in the minutes shortly after he fired at Mr. Suleiman?
Yes, I'm aware of the defendant making statements at the scene. And traditionally, I go back to when I was a lieutenant in the Internal Affairs Bureau. On many occasions, one of the things that would happen is we would visit the scene and there are certain questions that are asked, such as, did you fire your weapon and why did you fire your weapon? And that remained consistent with the statements that I reviewed in connection with the defendant in this case.
So you reviewed the statements that were captured on the 2 different body-worn cameras, one from the defendant, one from another trooper?
Yes.
And you watched all the accompanying body-worn camera and motor vehicle cameras, as you said.
Yes.
Did you read a report prepared by somebody named James Borden?
Yes.
Did you also read a report prepared by somebody named Paul Taylor?
My apologies. Yes.
And did you also review Connecticut State Police policies that would have been applicable or related to the events that occurred in this case?
Yes, I did.
How do NYPD policies compare to Connecticut State Police policies? I know you're probably more familiar with NYPD, but are they similar at all or different?
Gross similarities between the two. Just on a national level in policing, you have a lot of similarities in policing, as more so specific to use of force and vehicle pursuit policies.
And did you also review something called use of force, threat assessment, response management matrix with respect to this case?
Yes, I did.
And did one of those policies, by the way, that I referenced earlier in the Administrative Operations Manual of the Connecticut State Police, the one on vehicle pursuits, did you review that?
Yes, I did.
And did you do any personal investigation with respect to this case?
Yes, I did. I actually visited the scene right off of exit 43, and I actually went to where that overpass is located under I-95, and I was able to experience the sound reverberation in that particular area because based on it being under an overpass, sounds are more amplified than if it would be in a common setting on the street. So it was important for me to actually drive the route of the pursuit as well as where the final outcome of the events occurred.
Okay, and just to clarify, you did this at a time when there was just a normal traffic situation, not when there were police cars with sirens or anything like that.
That's correct. There were normal it was normal at the time, but I went at the time that the incident occurred.
Did that help at all form your opinions with respect to this case, that experience?
Yes, it was very important because I was able to understand the dynamic of the scene where the firearms discharge occurred, and more so specific to the sound amplification right under that underpass under I-95 at the exit 43.
You mentioned you worked in internal affairs for, I think, 3 years, and I think you said that part of that job entailed investigating officers' use of their firearms.
That's correct. Just a correction, I was actually in internal affairs for 7 years.
I'm sorry, 7 years.
That's fine.
And you, in your experience, sometimes officers make statements. I think you did say it's close in time to when those incidents occurred.
Yeah, traditionally, when an incident occurs, more so specific to a firearms discharge or a use of force, the one thing that you would ask the officer is, did he or she fire their weapon? And they would either say yes or no. And you would ask them why they fired their weapon. And the reason why you ask those questions, because that would determine if that officer, in fact, would be a subject in a further or ongoing investigation. So it's important for you to capture that information at that point in time.
Do sometimes officers make statements later on? Much later, at a later point in time.
Yes, it's commonplace for officers to make an additional statement after the fact. And generally, this is something that happens in the comforts of the officer being with an attorney and a union rep. And what traditionally happens in those types of settings is the attorney would oversee, which is the officer's right. The attorney would oversee a statement, and then that statement would now be forwarded to my office in internal affairs. But initially, there is a statement made by the officer, and then there's a secondary statement that's made by the officer with their attorney and a union rep.
In your experience doing these kinds of investigations, which statements have been more reliable to you?
Objection, Your Honor.
Sustained.
Is there a what else can be influenced by the statements that happen later on as opposed to statements that are given contemporaneously to the events?
After the incident, you have the ability to have someone that is a legal expert, such as an attorney or even a union rep, that would assist with the understanding of the violations of department policy. And usually what happens is the statements become more manufactured when the attorney and the union rep sit down and present that statement to us in the Internal Affairs Bureau.
So, in this case, the defendant made a statement, a written statement in February 2020?
Yes.
And
Yes.
If I told you that he gave testimony on Friday that introduced the idea, testimony as well, that's Friday, that introduced the idea that he perceived an imminent threat to Trooper Jackson and Officer Rappa, would that suggest anything to you?
That would suggest something to me, because when I look at the two statements, the initial statement mentioned nothing about Officer Rappa, an imminent threat to Officer Rappa and Officer Jackson. However, the second statement mentioned the imminent threat to Officer Rappa and Trooper Jackson.
And the first statements were made right after this happened, within a few, minutes after the event happened.
Correct. The first statement was immediately contagious to the event, and that was made to Sergeant Kiley and Sergeant Hennessy, and I believe Trooper Richter. And the second statement was made with the attorney, which was provided into evidence.
So the defendant testified on Friday about having a tunnel vision at the time that he fired. How might that affect just generally a police officer in their perception of where other officers might be if they say they have tunnel vision?
Tunnel vision is quite common. And when we speak to having tunnel vision, I give you an example of what happened in this particular situation. If an officer is looking into the front seat or looking at a subject, in this case it would be Solomon, it'd make all the sense in the world to me that the officer was unable to see what was surrounding because their focus was specifically to that subject. So to see something outside of that would appear to be unlikely based on the officer stating that they had tunnel vision because they specifically say that they're looking at directly what's in front of them.
Would a reasonable officer that was in Trooper North's position at that time have seen Jackson around?
Objection, Your Honor. Sustained.
I want to ask you about the concept of this flashlight that was on the defense weapon. He testified, and there's been other testimony, that through his training, it wouldn't make sense to move the weapon from the light because the light being attached to the weapon might change the sight picture of the weapon and maybe put somebody else in danger. There's testimony generally about that. In response to a question, did you consider that answer was given in response to a question, but did you consider whether or not you could have evaluated whether anybody was coming into the car? So my question to you is, knowing that was the device that Trooper North had, a high-power flashlight attached to his pistol, do you have an opinion about whether, seeing the video, knowing where Trooper North was standing and pointing his weapon with the light, do you have an opinion about whether that could have been evaluated in another way?
Your Honor, can I object at this point? It's compound, it's leading.
Could you just rephrase it?
Sure.
It is a little compound.
So I'm trying to give the witness a background as to the testimony. So there was testimony that the defendant was unable to move his flashlight attached to his weapon because somebody might have been put in danger, or that wasn't a safe thing to do. Would that light have provided illumination into the vehicle?
Your Honor, I'm going to object again. This witness provided an analysis about the incident at issue. He's being asked to comment on testimony.
Well, this is a rebuttal witness, Your Honor. He's being asked to comment on the defendant's assertion that he could not move his tools.
Well, I mean, he wasn't right. Could you rephrase it? I mean, you're asking for him to testify if something could have happened at the scene where he was not present to know all the conditions. That's my concern. So if you could just rephrase the question.
Sure. Knowing what you know from the video, where the defendant was standing, where the other officers were on the other side of the vehicle, would the defendant have been able to see into the car?
Yes.
How?
The flashlight was illuminated, and the flashlight is attached to the firearm. The flashlight is directly below the barrel of the slide of the firearm. So just based on that flashlight being attached to the bottom of the firearm, the illumination of the interior compartment would have occurred. So in answer to your question, yes, the defendant would have been able to see Mr. Soleimani in the vehicle, based on the illumination of that flashlight, because it would have illuminated that front passenger compartment.
Would that light, in your opinion, give him the ability to assess whether anybody else was coming into the vehicle?
I would say yeah.
Your Honor, that's speculation.
Yeah, I mean, you would at least need more of a foundation, I would think.
So you're familiar with this tactical light that would be on top of the, or attached like at the bottom of the barrel of one of these pistols?
Yes.
Is that different? Well, let me ask you this. If you researched that particular flashlight at all that was used in this case?
I didn't research that particular flashlight.
Are generally these lights more or less powerful in terms of the illumination than a traditional flashlight?
Objection, Your Honor. If he hasn't researched the flashlight, how can he then respond to that?
The flashlight, based on what you've seen in the video, and the amount of light that light displayed in the video from what you've seen from all angles, do you have an opinion as to whether or not somebody standing in where the defendant was standing would have been able to see the other parts of that vehicle?
Yes.
Your Honor, again, it lacks I'm sorry, lacks foundation. Again, and a comment on something that he hasn't researched. He doesn't know.
Sorry, go ahead.
He doesn't know about this light, so how can he now comment on it? And it lacks foundation.
So it's not, so my response, Your Honor, it's not based on his research, that's specific light it's based on. The question now is tailored just to ask him about what he observed in the videos that he saw.
I'm sorry, I'm confused. Are you asking him whether when he viewed the videos and stuff, could he see whether there was anybody in the car?
Whether his view of that angle from where Trooper North was would have provided illumination in other parts of the vehicle.
Well, doesn't the video show that?
I think that's been a matter of dispute, Your Honor. I think that
Whether it shows it is a matter of dispute?
well, not it's
Just so I'm not trying to, I'm just trying to understand whether you're asking whether he's being asked for an opinion on whether someone standing where the defendant was standing could see other people in the car given the flashlight, or whether he was able to see, given the same view as the officer virtually anyway, whether there was other people in the car because of the flashlight. That's what I'm confused about.
the question, Your Honor, is whether or not, based on the amount of light that he sees coming out of that flashlight, he can make information as to whether or not that was illuminated in other parts of the vehicle.
Without knowing anything about what else was going on in the vehicle, right?
Right.
Obstructions and the like.
Correct.
I'll sustain the objection.
The point in time just before the defendant fired, the window shattered, the glass on the seats, and the suspect possibly armed with a knife, maybe tased. Would a reasonable police officer have gone into the car at that point?
Objection, Your Honor.
Your Honor, you can testify what a reasonable police officer would do in that situation.
These are the ultimate issues. It's 7-3.
Well, this is my response to you. This is a different type of question than what was asked yesterday.
Well, whether it's different or not from yesterday, it does seem to go to the ultimate issue, doesn't it?
Well, I think the question is what a reasonable police officer would do, not whether or not North's conduct was reasonable. The question is about what a reasonable officer would do, and that's what.
I'm going to sustain the objection.
Knowing everything you know about, knowing your training experience and knowing everything you know about the situation, what a reasonable police officer have gone into that car.
Objection, Your Honor.
Sustain.
There's been testimony from the defendant and from others that it would not have been possible to take a tactical pause once the pursuit ended. Do you agree with that?
No.
And tell us why.
When the pursuit ended, the vehicle that Mr. Solomon was driving struck an SUV in front of him. In addition to that, we had the two vehicles, one that was driven by Jackson and one that was driven by North, that had the vehicle boxed in. When I say the vehicle, I'm referring to the white Hyundai Sonata. When the officer, when the defendant first approached Mr. Solomon, he mentioned that he appeared as if he was out of it. So when we look at the vehicle pursuit policy for the Connecticut State Police, one of the things mentioned is to have a supervisor should control and direct the pursuit. So based on Mr. Solomon appearing to be out of it, that would have been the perfect time to take a tactical pause and allow a supervisor to respond and create a plan of action in terms of how they would address that vehicle.
Would a reasonable police officer have done that?
Objection, Your Honor.
I'll sustain that.
Would at the time from the stop, when everybody stopped and the defendant got out of his car, was the time that he shot Mr. Suleiman was about 35 seconds, would you agree?
Yes.
And you're saying that tactical pause could have been taken because Mr. Suleiman was, as the defendant testified, out of it at that time?
Yes.
I want to ask you about this. There was some testimony about one shot, two shot drills. Could you tell me what do you know what a one shot drill is?
Yes.
And have you ever conducted a one shot drill?
I participated in one-shot drills, and the reason for the one-shot drill, I'm sorry.
I'm going to object. regarding this line of question, because the gentleman testified that he's not a firearms instructor. He just said he participated. He's not an instructor, so.
Well, the question was just whether he's familiar.
Correct.
I think-
And part of the gentleman's response was,
Well, he answered the question, I think.
okay, well, I would object to that line of questioning. He's not an instructor. He's been a participant, it sounds like. He's never been an instructor in that regard.
Well, we'll see where it goes, but I'll allow that answer, the answer which was yes, basically, in other words.
And are you familiar with what the purpose is of a one-shot drill?
Yes.
And how is it that you know that information?
Based on my experience in the NYPD's police academy as an instructor, as well as my experience as a police officer in the NYPD that participated in qualification twice a year.
So what is the purpose of one-shot drill?
The purpose of a one-shot drill is for you to fire. Every shot that you fire must be justified. Whenever you're using force or deadly physical force against a subject, you have to justify every single shot. So the one-shot drill affords you the ability to fire, then assess if you should fire again. And if the need is necessary, then you would fire again.
Are you familiar with the concept of target glancing? Have you heard that term before?
Yes.
And when you view the videos in this case, did you see anything that resembled target glancing?
I didn't observe anything that was reflective of target glancing.
So there's been testimony that by some witnesses that the situation here where the vehicles were stopped does not meet the criteria of a felony stop because of, I guess, the manner in which the car was stopped. In other words, like you mentioned, you hit the car in front of it as opposed to stopping another way. Do you agree with that?
I disagree.
And tell me why you disagree with this. Does this meet the definition of a felony stop?
I believe it does.
The felony stop training has been used in this case.
Yes.
And would a police officer consider that?
Objection, Your Honor. Sustained.
Well, you mean in the context of this case?
Well, I'm asking it as a hypothetical, I guess, Your Honor. So I would claim it as a hypothetical.
Well, then rephrase it as a
A
hypothetical.
situation where, in this particular, putting aside these particular facts, in a situation where a vehicle crashes into another vehicle and the occupant of the vehicle does not sort of motionless in the car, if you will, but doesn't say come to a voluntary stop or isn't stopped forcibly by a police officer. Would a situation like that constitute felony stop procedures be used? Should felony stop procedures be used in a case like that?
Yes.
And are you familiar with the felony stop procedures that were that was trained on?
Yes.
Is there time to do that even in a situation that might be described as rapidly evolving?
Yes.
So was there a level of urgency in this situation that required Mr. Suleiman to be executed?
No.
During vehicle pursuits, is there an emotional factor for officers that are involved, just in general?
Yes.
Is adrenaline high?
Yes.
Is that why the policy dictates that supervisors take control?
Yes.
And what might have, we can talk about this a little bit, but what might have that look like if supervisors were called?
Objection, Your Honor.
Well, I'll withdraw. In a situation where there's some officers that are not supervisors involved in a pursuit, and the pursuit ends, and a tactical pause is taken, and a trooper decides or an officer decides to call the supervisor to the scene. In your experience, what typically happens?
Objection, speculation.
I think he's an expert on this issue, Your Honor.
Well, let's just go question by question. I mean, so generally, what typically happens? Yeah, what typically
What would
happens?
happen? What would a supervisor add to that situation?
So that's the question on the
Yes.
floor now. Thank you.
A supervisor adds a wealth of knowledge to a dynamic situation such as this. Based on their rank as a supervisor, you take an exam that tests what your credibility is to become a supervisor. So what you now do is you implement the practitioner, your skill as a practitioner in how communication would be handled and what the positioning of officers at the scene would be.
And the supervisor is called to the scene. Your experience as adrenaline be as high as the officers that were called in pursuit?
As a supervisor, and we refer back to the Connecticut State Police policy on pursuits, it specifically mentions that adrenaline can run high. However, the supervisor is brought in to assist and I want to say use the best method in bringing that individual into custody with I want to say minimal injury to either the officer or the subject at hand. So the supervisor would be deemed as the practitioner expert in that particular scenario. Because remember, you have to take a test to become a supervisor. And based on the outcome of that exam, it's a reflection of you have the understanding on how to manage situations of this magnitude.
And would the supervisor help develop a tactical plan in that situation?
Yes, that's one of the things that a supervisor would do. He or she would assist in developing a tactical plan as well as communications amongst the people that were on the scene in this particular instance.
And a tactical plan is meaning that, as you said, result in a scenario that would be safe for both the officers and for the person in the car.
That's correct.
I want to show you. I want to show you two slides from Exhibit 46, which is the training that Trooper North was trained on. We can just show. So the jury's seen this slide. This is a slide that I forget the number, but it's in the PowerPoint presentation that Trooper North was trained on. That was trained on. Have you seen this before today?
Yes.
Okay. And does this the felony stop training that we're talking about, would this have been, this is a Connecticut policy, but does this comport with your understanding of what felony stop training, at least a portion of it, would consist of?
Yes.
The key points would be communication.
Yes.
Do not approach the car.
Yes.
And why is that?
Well, the communication is important because it affords the subject that you're trying that you want to bring into custody the ability to acquiesce to your commands. And so I give you an example. Under that that underpass at I-95, you had sirens blaring. And the best way to describe it is it was kind of like an amphitheater because the sound reverberates so much. So by turning off the sirens in a situation like that, you would have the ability to communicate with the subject and have them come out of the car on their own because it's just so much safer when you do it that way, as opposed to going in and doing the extraction yourself.
And can we just go 2 slides up? So this is a photographic presentation of what that might look like.
Yes.
And what, could you just kind of describe what we see here?
What you see is you have a potential subject vehicle that's in front of the 2 police vehicles. And you have the 2 vehicles behind, the 2 police vehicles behind the subject vehicles. And it appears as if there's a level of communication that's occurring. Now, I can't tell you if they're using the PA system or they're speaking verbally, but it's important for you to amplify your message to the individuals that are in that civilian auto. But at the same token, the officers are maintaining something we refer to as cover. The cover is important because it avails you more time to deal with the individual that you're trying to bring into custody or the individual in question. So it gives you something we refer to as time, distance, and cover.
And that's to protect both the officer and the person in the
That is correct.
And you mentioned the PA system in the vehicle. That's the way to communicate.
The PA system is a very important means of communicating with an individual during a car stop. And like, as I mentioned, they were under an overpass in this particular situation. Sound is reverberating based on the siren. So it would have been difficult to speak over that siren, so to speak, based on the way this, that underpass or overpass, as you want to refer to it, that is constructed. So, but that communication is key.
Would it be helpful to turn the siren off in that situation if it's not?
Absolutely, because remember, you're providing instruction to the individual during this car stop, and you want the person to understand and hear what you're saying so they can comply with your requests.
And at the time that at the time of this incident, was the sirens on or off?
At the time of this incident, based on what I viewed on the video, the sirens were still on. It was and they were very loud.
And was it a PA system used at all?
The PA system, from what I saw, was not utilized during the time of this car stop.
From the time that the stop happened until the words "shots fired" were called out on the radio, were there any other radio transmissions that you observed?
There were no additional radio transmissions from the time that the defendant got out of his vehicle until when the shots were fired. So I want to say it was roughly 35, 36 seconds.
And that was actually the transmission, shots fired.
The shots fired was at 35, 36 seconds.
So there's testimony that the defendant and other troopers actually did use de-escalation techniques in the form of a taser deployment. Do you agree with that?
No.
In other words, that's not. Could you elaborate a little bit?
Sure. When we look at a taser deployment in a situation such as this, and you go to the Connecticut State Police procedural guidelines, it prohibits tasering someone if a vehicle is in gear. So this vehicle was in gear because the only reason why the vehicle stopped was because it crashed into a civilian vehicle in front of it. So in all likelihood, you can assume that the vehicle was still in gear. So the taser use was a prohibited act, which occurred based on Officer Jackson's, I should say Trooper Jackson's actions in this particular case. So it would not be de-escalation because it was prohibited by department policy.
And go back to the slide that you saw. The troopers going to take cover behind the vehicles like that. Would it be better in a situation like that to have the goal to kind of have the person come out of the vehicle on their own?
When we look at the felony car stop procedure, it states you want the person to come out on their own because it's just so much easier for the officer to take someone into custody, and it's safer because if the person comes out on their own, you can continue to give them more commands such as turn around, put your hands behind your back, and then the person can be handcuffed. But it's the policy specifically focuses on have the person come out of the vehicle, don't go in and do the extraction.
So just hypothetically, a vehicle, there's a vehicle pursuit, it stops, maybe there's an accident, and roughly, less than a minute after, the officers get out of the car and surround the car. And by the way, it would be dangerous to go. You say it's dangerous to go in front of the vehicle, and is that what they're taking cover in that photo, for example?
Yes, it would be dangerous to go in front of the vehicle, but just think from a common sense perspective, if you're standing in front of a vehicle, you can get hit by the vehicle. We don't want that to happen.
So hypothetically, if there's a vehicle stop that's, you have three or four officers that are involved in a vehicle stop. You have sirens, noise. You have a person occupant in the vehicle that's not actively moving, really. That's sort of just remaining still, essentially. And the officers go up to the car, and one officer sees some movements, maybe sees the person in the car pointing a knife directly upward. Would a reasonable police officer fire 7 shots at that?
Objection, Your Honor.
Hypothetical question here.
Yeah, sort of. I'm going to sustain the objection, but if you could rephrase it a little bit.
Well, would a reasonable police officer in a situation where they have the vehicle surrounded, there's windows are closed, one window is maybe open on the other side, and the suspect has a knife that's pointed in a direction that's not threatening to anybody. Would a reasonable police officer use deadly force in that situation?
Objection, Your Honor. Ultimate issue.
Yeah, and there's some conclusions and presumptions in the question. I'm going to sustain the objection.
I think at that point, no further questions.
Thank you, sir. Cross-examination, Mr.
Thank you.
Good morning, sir.
Good morning, how are you?
All right.
We've never met before, correct?
No.
Okay.
I think you owe me some cash, but outside of that,
I object to that.
you got to break these things up. I'm sorry, guys.
It's sustained.
He sustained the objection, not me.
Great. I represent Trooper North.
All right.
So you talked a lot about the felony car stop through questions from Attorney Slip. And isn't it true that and you've reviewed the facts and the reports and the videos from this incident, correct?
Yes, sir.
And isn't it fair to say that the way that this incident unfolded did not unfold like any traditional felony car stop? Isn't that fair to say?
My answer to that is it's very difficult to say what is a traditional felony car stop. And if we focus on the incident in hand, I can give you a better dissection as to what's there, because it just felony car stops there's multiple ways that could occur.
Well, for example, in felony car stops, that terminology, if you will, applies to a situation when an operator complies to the officer's request to pull over or otherwise stop the car, correct?
Correct.
Felony car stops apply when that operator actually does voluntarily come to a stop per officer's request, correct?
Correct.
Felony car stop applies then when that operator turns his or her engine off, puts his keys on top of the hood or the roof, correct?
Correct.
So the felony car stop traditionally is when the operator of the vehicle fully complies with the police's request to pull over and in fact does pull over and submit to the authority of the police, correct?
I disagree. If the vehicle is stopped.
All right, well, I'll ask you a different way.
I'm sorry.
That's all right. We can agree that the way the felony car stop rule applies is, as you just testified, when the operator voluntarily stops. Correct?
No, once the vehicle is stopped.
Okay. But that the vehicle is stopped through the voluntariness of the driver of the car. Police signal to pull over, that car is pulled over. Correct?
And it goes back to the voluntary nature. And my understanding of felony car stop is when the vehicle is stopped.
Is that the way? Well, aren't police officers trained in felony car stops that it applies when cars come to a stop on their own? The operator stops the car.
My understanding of a felony car stop is when the vehicle is stopped.
And again, we may be mincing words, but the point of the point of my question is felony car stops apply when a operator complies, stops the car, turns off the car, that's when a felony car stop actually applies.
Objection, I think he's asked to answer this 3 times. He just doesn't agree with counsel characterization.
Well, I've heard the answers to the questions, and they have not necessarily, either the question or the answer have not corresponded. I think he's trying to establish communication with the witness, and it's not because the witness is not being cooperative. It's just they're sort of missing each other, it sounds like. I'll allow the question.
And I don't mean
In fact, maybe you should just withdraw it and ask it again.
I'll withdraw it and I'll ask it one more time. Felony car stop rule applies when a car voluntarily stops by the operator and is not stopped by police.
My answer to your question is it's not necessarily, it doesn't have to be voluntary, but the felony car stop is when the vehicle is stopped.
As we saw in the photograph just moments ago, another element of the felony car stop, I believe you testified to, is the positioning of the officers, correct?
Yes, sir.
And in fact, I think you just said moments ago that it's dangerous. It would be dangerous for the officer to be in front of the car.
Correct.
And in this case, we can agree, you've watched the videos, Trooper North was not standing in front of that car, in front of the hood of the car, correct?
Correct.
Now, if police take the traditional position of behind the suspect car, isn't it true that if, let's say, a civilian vehicle was in front of that suspect car, that civilian vehicle is now in the line of fire?
Counsel, I want to answer your question, but I think it's hypothetical because we don't have a situation where a firearm was established nor identified. So when you say the line of fire, granted, there was a civilian vehicle in front of the white Hyundai, but a firearm was not introduced into the equation as it relates to the subject. So I just don't see how that lines up with this.
You would agree with me that it would be unfair to hypothesize facts that didn't occur, correct? That's unfair to do, correct?
I'll say correct. However, if I have to self-correct as we move forward in the question and come back to it, I'll address it.
And that's fine. But like, for example, you provided analysis in this case. And isn't it true that if you're being asked to provide an analysis, let's say, of the facts of this case, you only can analyze what actually happened and not what could have happened, what should have happened, correct?
Correct.
Now, in your sort of question to my question, I asked if a gun was introduced in that picture and the officer had to fire that gun in the direction he was facing, assuming it's a male officer. If he had to fire that gun, that civilian vehicle in front of the suspect vehicle is in the line of fire, correct?
And counsel, once again, you're suggesting that the subject vehicle was in possession of a firearm, correct?
Negative.
Okay.
What I'm saying is, let's say the police officer had a gun.
Yes.
And the police officer is behind his car in this example. Suspect car is in front of the police car. That's what the picture showed, correct?
Yes.
There's a civilian vehicle in front of the suspect car.
Correct.
With me so far?
Yes, sir.
If the police officer had to fire his weapon, in the direction he was facing, in this example, isn't the civilian vehicle in the line of fire?
Yes. However, that situation was a training video where there were no cars on the street. When we speak to a tactical plan, when an officer conducts a car stop, they should remain cognizant to what's in front of them and position themselves accordingly based on the situation that they have.
Policies in any state, police policies, are just that, right? So policies and not black letter law. Is that fair to say?
Yes, sir.
And policies are implemented and used only when feasible and able to, correct?
Counsel, I disagree. I think policies would maintain the structure of any organization. And I think that it's necessary for us as employees of a particular organization to follow those policies. When we deviate, it creates a problem. So I believe that we should follow the policies.
Now, but again, you agree, not black letter law, but just policies, recommendations of how a police officer should act in many circumstances.
I'm sorry, counsel, can you repeat that?
Sure.
I apologize.
It's all right.
All right.
Just repeating what question earlier. Well, I'll move on.
Okay.
Now, you mentioned about plans. There was not a plan, or there was not a supervisor or something like that. Let me ask you a couple questions in that regard. You agree that 35 seconds is the time that elapsed from the moment the event started to the moment it ended, correct?
Yes, sir.
And your testimony is that in that 35 seconds, there should have been a supervisor who should have come to the scene and done something.
Well, no, that wasn't my answer. My answer was, in that 35 seconds, you had the ability to request a supervisor. And while requesting a supervisor, based on Mr. Solomon, as the defendant mentioned, appearing to be out of it, it would have given you some time to implement something we refer to as a tactical pause. That tactical pause would have availed officers to take a position pending the arrival of a supervisor.
The police officers in this case came upon an unconscious subject, and moments later, another police officer from another police agency started banging on the window and breaking it. Agreed?
Yes, sir.
And we can also agree that Mr. Suleiman reacted to that window being broken, correct?
Correct.
And Mr. Suleiman, without any planning, withdrawn. Mr. Suleiman went from essentially an unconscious state to a conscious state because of something somebody else did, meaning the West Haven officer, Rappa, correct?
Correct.
And the material that you reviewed shows that it was a matter of seconds from when police left their car and Trooper North left his car to when that window was broken, correct?
Correct.
And it was the breaking of that window that changed the dynamic of the entire situation, because Mr. Suleiman then reacted as a result, correct?
Correct.
So we can agree that had, again, woulda, coulda, shoulda, we shouldn't be doing that. But had Mr. Suleiman remained unconscious, that would maybe be a different story. Is that fair to say?
We're speaking of hypotheticals, but I'll agree with you, counsel.
But that's not what happened, because the evidence you reviewed shows that Mr. Suleiman came to within moments of that window breaking. In fact, it's simultaneously with that window breaking, correct?
Correct.
Now, your testimony was critical of the way police handled this, and as far as communication or lack thereof. You reviewed, in addition to the material you reviewed, you also reviewed, did you not, any dispatch recordings and communications between the officers?
Yes.
And in those recordings, isn't it true that the sergeant, the supervisor, was in communication over the radio from Troop G, meaning the troop? Isn't it fair to say that there were communications between the supervisor and these officers?
So what?
The question was, it was asked on the record related to the communication at the scene, not before.
Well, I mean, it's his question, right?
I would object to the form of the question.
Can you rephrase it?
I will. Was there communication between the supervisors and these officers during this entire episode, from the pursuit forward?
There was communication during the pursuit. However, At the time of the stop, there was no communication between the officers and a supervisor. And I'm referring to the 36 seconds from when Officer North got out of his vehicle to when he discharged his weapon. There was no communication.
Now, just
with
out of
supervisor.
curiosity, sorry, I didn't mean to interrupt.
No, I apologize.
Just out of curiosity, do you know how far away Troop G is from this exit 43 overpass? Oh,
I don't know how far away it is, no.
okay. If I told you 20 minutes, would you have any reason to disagree with me?
Objection, he's got no knowledge of that, Your Honor.
All right. It's fair to say that the supervisor was not on scene, correct? From what you understand, the supervisor was not on scene, correct? He was at the troop, if you know?
Well, I don't know where the supervisor was located, but I can just speak from my personal experience. As a patrol supervisor, you're not sitting in the precinct. Your job is to actually be in the field and supervise the members, the officers that are in the field, and not just come out when a disturbance happens.
But we can agree that the person on trial in this case is Trooper North and not his supervisor. Is that fair to say?
Yes, sir.
Sir, you spoke of a tactical pause. Again, this incident from exiting his vehicle to firing his firearm was less than a minute. Is that fair to say?
Yes, sir.
And where can the tactical pause take place when there are conditions like the breaking of a window that are against the control of an officer? How can you pause when the situation is moving and changing with every passing moment?
The first thing is someone has to establish a level of communication. And it's so simple as a police officer, and I'm not even speaking as a supervisor. If I see something happening, I can direct and tell people just take a step back, take a step forward, etc. So when we speak to a tactical pause, it's just merely saying, hey, look, guys, let's just take a step back. Let's wait till the boss gets here.
So for a tactical pause, you want to establish communication. Is that fair to say?
Well, communication is a part of it.
How do you communicate with someone who's unconscious?
Well, when I mentioned the tactical pause, and I was responding to your last question, counsel, when you said that the window was being broken, you can just merely merely tell people to take a step back. But communicating over the PA system or verbally is of optimum importance for you to assist you in achieving your goal. If you don't give someone instructions, they have no way to respond.
Now, sir, again, you're aware of all the evidence in this case that you were sent, correct?
Yes, sir.
And that evidence that you were sent contained, correct me if I'm wrong, what Mr. Suleiman did in Norwalk through West Haven, correct?
Yes, sir.
So the evidence you had showed that he pulled a knife on somebody at the AT&T store in Norwalk. Your evidence shows that, correct?
No.
Your evidence didn't show that there was a knife pulled at a cell phone store in Norwalk?
I would object, Your Honor. I think that's not a fair characterization of the testimony from earlier in the week. From last week, actually.
I will sustain it, but just rephrase it.
Did your evidence that you review show that Mr. Suleiman displayed a knife at an AT&T store in Norwalk?
Correct. The knife was displayed.
Did your evidence show that Mr. Suleiman stole and carjacked stole a vehicle from a Lyft driver in Norwalk?
The evidence did show that a vehicle was taken from the Lyft driver in Norwalk. Correct.
Your evidence showed that Mr. Suleiman drove from Norwalk to West Haven at speeds eclipsing 100 miles an hour, correct?
Yes, sir.
The evidence showed that Mr. Suleiman, while driving up to speeds of 100 miles an hour, was driving recklessly across all lanes of traffic on an interstate, correct?
Correct.
The evidence showed that Mr. Suleiman successfully was able to find his way out of being boxed in by two police officers, correct?
Correct.
Mr. Suleiman struck a civilian vehicle at exit 40, the off-ramp of exit 43, and didn't stop on his own, correct?
Correct.
So with Mr. Suleiman complying at no point for a half hour before this incident, you think he's going to comply now?
For speculation.
Same.
Your training experience certainly shows that you trained officers in New York State. Or is it New York City or New York State or both?
Well, New York City, but New York State is the presiding authority, so you're right on both fronts.
Okay. Excuse me, did you ever train any police officers in Connecticut?
No.
Okay.
Actually, withdrawn. There have been officers from Connecticut that have trained when we've had multi-agency exercises in the city of New York, and it goes back to after 9/11.
Okay.
And I was an instructor in the police academy during 9/11.
Gotcha. The state of Connecticut has retained you for this case for you to provide analysis and testimony.
Yes, sir.
And what is your rate for your testimony and your analysis, your work in this case?
$300 an hour.
And for how many hours have you in total worked this case, including your testimony today?
I would have to look at that, but I think I've billed, say roughly maybe $10,000 up to this point, somewhere in that area.
Now, you also mentioned that you've testified 3 times before this testimony.
Yes.
Those 3 other times that you've testified, have you testified on behalf of the prosecutorial agency?
No.
Okay. Have you ever testified on behalf of an accused?
No.
I know you were asked questions about whether you reviewed reports by Mr. Borden and Taylor, correct?
Yes, sir.
And isn't it true that you have attended some trainings by Mr. Borden?
Well, not exactly. We've attended training together, but it was never a situation where Borden was the facilitator. So we were both pupils in the same arena.
Just a final couple questions, sir. You spoke. You made some comments regarding statements made at the scene versus statements made after the fact. Do you remember those questions?
Yes, sir.
Are you aware of any policy in the state of Connecticut that dictates when a police officer has to give a statement to his superior?
No, sir.
Now, the statement after the fact, again, is there any policy stating how long or how short it has to go by before someone can provide a written statement to authorities?
No, sir.
Can I have one moment, Your Honor?
Yes.
Just a couple final questions, sir. In your analysis of the evidence provided, isn't it true that there was a Sergeant Zwickler who was part of the on-scene population of cops when this incident took place?
Yes, sir.
And a sergeant is a supervisor over troopers, correct?
No, Sergeant Zwickler did not have supervisory or command authority over the state police. He only had supervisory authority over Rapper and the third officer that was on the scene, the West Haven officers.
And finally, sir, in speaking about use of force, isn't it true that the analysis in using use of force is about what the police officer was experiencing at the time, and it's unfair to look at this in 2020 hindsight?
That's a complicated question because it goes to yes and no. Although an officer sees something, the officer has to act as a reasonable police officer, not just because they want to do whatever they want to do.
But isn't it true that the law states that 2020 hindsight is not an acceptable way to analyze things like this?
Objection, Your Honor, with respect to commenting on the law.
I'm sorry?
Objection with respect to the witness commenting on the law.
I'll sustain it.
I know the questions. Thank you very much, sir.
Thank you, sir.
A few follow-up, Your Honor. Dr. Porcher, you, I think, just to clarify, you may have misspoke. Did you say $10,000 or 10,000 hours?
Oh, $10,000. I'm sorry, 10,000 hours. Are you kidding me? I would own the judge if that was the case. All right.
So just thank you for that clarification. And to be clear, is your opinion at all influenced by the rate that you've been paid?
No, sir.
And you are, as you said, one of your occupations is to occasionally consult with the expert witness in cases.
Yes, sir.
You were asked about policies. Policies aren't just suggestions, are they?
No. Policies are not suggestions. Policies are rules that are established by the department hierarchy based on their understanding of what best works for that organization.
And you worked in internal affairs for 7 years?
Yes, sir.
And officers can get in trouble for violating policies, correct?
Yes, sir.
So you're asked about communication at the scene. The only communication at the scene, once this, collision happened under the bridge, the only communication before shots fired was the defendant telling Jackson to go to taser. Was that right?
I'm sorry, I couldn't hear you.
Sure. The only communication that happened among the officers at the scene was the defendant telling Jackson to go to taser. Is that right?
Yes.
Thank you. Nothing further.
Nothing more. Thank you.
Thank you. Thank you, sir. You are excused. Last witness?
That's it. We're at the state restaurant. Thank you.
Thank you. So now the evidence is complete, and I'm going to excuse you just for a morning break for 15 minutes, and then I expect that you'll be hearing from the attorneys, and we'll set up the room. So we'll see you at 25 of 12. So we're in recess. Do not begin to discuss the case. Thank you. Anything to take up?
Oh, no, Your Honor.
Do you want to move, do you want to use the podium or anything?
Yeah,
like-
I've asked Marshall to move the podium here and
He's got it. Okay.
I think with the clerk to get some exhibits before argument.
And make sure that have you guys been through the exhibits with the clerk?
No, we will though.
Okay. All right, so plenty of.
All rise.
Your Honor, he's gotta let everybody in. Still trying to figure out the technology issue. I may just have to do it that way.
Want to go off record?
Well, yeah, but you don't have to be really.
Summations. Attorney Devlin and I will meet with Devin one final time to make sure everything's in order.
Yeah, no, that makes sense. And so if they want to hear or see anything, can bring them back into the courtroom.
Well, we're going to provide the.
I mean, it depends on what it is. Yeah. I'm sorry.
The plan was to provide the jury with a computer.
Okay. So
The
what were you?
plan, Your Honor, is to allow the jury to have a computer, which we have, that's a clean computer, that they could take these thumb drives that are in evidence in and play them in the jury room at whatever speed or frequency they wish to do it. They wouldn't have to come back into the courtroom every time to see it.
I would. All right. Does the defense have an issue with that?
No.
Okay. And so we know it's clean. Do we know they're going to be able to run it?
Well, we'll have to find out. I assume they will. It's not complicated, but
Well,
if
I mean, I
they
saw you
don't,
guys.
if they don't, I suppose the court will instruct them to send a note out, and we'll have to address that.
Okay. Anything else before we bring them in? Okay. So let's bring the jury in.
Your Honor, 60 minutes for each.
60 minutes, however you want to use it. And we're going to go right through. I'm going to tell them,
Right.
unless one of you has an objection.
State will stipulate to the jury, Your Honor.
So stipulate as well.
Thank you, gentlemen. So now the evidence is complete, and you're going to hear the closing arguments of the parties. The state will have the opening or first argument and the closing or third argument, and the defendant will have the second argument, the one sandwiched in between. The state opens and closes the arguments and addresses you twice because the state has the burden of proof in a criminal case such as this. Though the state has two arguments, each party will be allotted the same total amount of time to argue, and however they want to use it, they'll be able to do that. It'll be about an hour each. Bear in mind that these arguments are not evidence, but are rather intended to help you in understanding and interpreting the evidence and understanding the claims of the parties. From what I just said, you may glean that we'll probably go till close to 2. And I address this to the staff as well. Absent objection from the jury or the staff, that's what I intend to do, so that the arguments can be kept together. And then you can take lunch, and then you come back. I propose to have you come back, and I will instruct you on the law. Does that seem like a plan?
That's good.
Okay. All right. Mr. Devlin or Mr. Yeah.
Well, good to see all of you. And thank you very much for your service on this case. I watched you during the trial. I know you're concentrating on the evidence and the testimony, and that's important because later on today, when you get the case for a decision, it's that memory of the testimony and your impressions of the witnesses that you're going to have to draw upon in making your decision. So this jury trial institution that you're a part of is really quite old. It's over 600 years old. And, when we started our country after the Revolutionary War, we rejected lots of things about the British system, but we kept trial by jury. And it's endured really for two reasons. One is it's a good way to get at the truth. You take 6 people and their life experience and their common sense. It's a very good way to sift through conflicting testimony and determine, what really happened in a particular instance. But another reason why I think it's endured is because it tends to help the legal system as a whole. In case after case after case after case, thousands of jury trial cases we have in America, jurors follow their oath. They just decide the case based on the facts and the law. And that resonates with the public. Americans respect the law, and a big part of that is because jurors, following their oaths, decide these cases fairly. So the judge is going to talk to you about the crime here, which is manslaughter in the first degree with a firearm. He'll instruct you on the elements of the crime. I'm just going to go over them briefly, but the judge will give you detailed instructions on that later on today. Basically, what this crime requires is that the state prove that someone, the defendant, acting with extreme indifference to human life, recklessly engaged in conduct that created a grave risk of death to someone and caused their death, and did so with a firearm. So extreme indifference to human life, recklessly engaged in conduct, created a risk of death, caused death with a gun. And then the defense in this case, which the state has to disprove, is that it defends a third party. Meaning, under the law, a person can use deadly force to protect others from imminent use of deadly force. The other person must face an imminent threat. And so this use of deadly force has to be objectively reasonable. So that means that a reasonable person, or in this case, a reasonable peace officer, in the same spot as the defendant would believe the same thing. And the judge, again, will give you more detailed instructions on that. So let's talk about the evidence a bit. And I'm going to start at exit 43. You heard evidence about other, Norwalk and the highway. I'm going to start at exit 43 because I think that's the pivotal evidence in this case. We heard from this lady, Jody Longley, who lived on Campbell Avenue, right near this overpass. She testified that she was driving her car on Campbell Avenue, and she came to just about the point where Campbell Avenue starts going under I-95. And she sees state police cars coming down the exit ramp on the other side of the highway from where she is. The cars approach her. They're chasing a white car. She sees a state police car, pin the doorway of one of the cars. Troopers get out. They have a gun. She hears 5 or 6 shots. Significantly, from our point of view, I would suggest that she can, from her vantage point in her car, she can see inside that white car. It's illuminated inside the car. And she can even see some slight movement of the arm of the operator of that car. We heard from Cordell Miller. He's the gentleman who's driving the Trailblazer. He's driving down Campbell Avenue. As he's approaching this exit ramp, he sees the police cars coming down the exit ramp. He pulls his car to the side. There's a rear-end collision, and he's looking in the rearview mirror of his car. He's sort of leaning back, and he says he sees a trooper with a gun. And 20 seconds after this collision, he hears gunshots. 20 seconds. So what I'd like you to do is just consider the state of affairs then, okay? This is before any windows are being broken. This Hyundai is stopped. Trooper Jackson's cruiser is against the driver's door such that the driver's door cannot open more than 1 inch. It is impossible for the driver of that vehicle to exit the car from the driver's door. North cruiser is diagonally across. The Hyundai is in front, and Trooper Darling's cruiser is behind. So you've got sort of police cars and civilian cars surrounding this Hyundai. Trooper North is at the driver's door with his gun aimed at the driver. Jackson's at the passenger door with his gun aimed at the passenger window. As Jackson has left his cruiser, he's running around the front of the Hyundai yelling, "Get out of the car," twice. And basically, as has been sort of said, and as you see in these body-worn cameras, it's really debatable whether Mr. Suleiman even heard that. But those are the only words that were said to Mark Suleiman before he was killed. And like I said, he probably never heard them. So the West Haven Police Department was there. They had their guns drawn. The Hyundai windows were up and the doors were locked. Mubarak Suleiman, multiple witnesses have described him as being out of it at that situation. He's sort of leaning back, out of it. He posed no threat to anybody. And you got a car surrounded, you got an operator who's out of it, who's leaning back, police officers around it with their guns drawn. This situation should have ended up better. I mean, it really should have ended up better. So we heard from Sergeant Zwickler from the West Haven Police Department. He's in charge of the street crime unit that they have. They're listening to these radio broadcasts. They go to the scene of the state police pursuit to assist. This wasn't their case. They're in the West Haven Police Department. They just overhear this on the radio and they go there to assist the state police in their investigation. He goes there, he parks behind the state police vehicles. He sees a lone male in the car. So from where Sergeant Zickler is, he can look into the car and see a lone male in the driver's seat. He indicated that there was no communication among the police officers there. There was no plan among the police officers there. After the window shattered, he sees the driver reaching into his pocket or in that area, and he yells out, "He's reaching, he's moving," or some words to that effect. He says, I submit importantly, nobody's entering the car through the window of that Hyundai. Nobody is. And he said, because it's highly dangerous to do something like that. Heard from Officer Rappa. Rappa testified that he arrived at that scene with Sergeant Zwickler, that he also noticed that the driver was out of it, that nobody was in command of the scene. He testified that he broke the window to the Hyundai for the purpose of addressing communication to Suleiman and maybe using some less lethal force to take control of him to get him out of the car. He also saw movement. He also yelled out, "He's reaching," and then almost shortly after that, he hears gunshots. So Officer Rappa breaking the window is sort of a watershed moment in this whole case, in the sense that at that moment, Mubarak Suleiman comes to, and that's due most likely to the sounds of this baton banging against this window over and over and over again, to the glass shards coming into the passenger compartment of the car as the window ultimately does shatter, as this taser that's being aimed at him by Trooper Jackson. And so he twists in his seat towards all this commotion. So there's banging on the window by the baton, there's glass shards coming in, and he twists to see, where's this coming from? And he then, at that point, he never leaves his seat. He twists in his seat. Again, he poses no danger to Trooper North. He poses no danger to any of the others either. He merely twistiness. He never moves toward them. He never tries to get over the console or into the passenger seat, all of which he'd have to do in order to exit the car to pose any real threat to anybody. They're outside. He never did any of this. And within seconds, literally seconds of this window breaking, North fired 7 shots at Suleiman through the driver's window, killing him. 7 shots. I submit to you folks, that's extreme indifference to human life. 7 shots at his chest. But that's what he does. It's complete overkill. So we heard from the officers who are at scene, their collection of evidence, they're taking of photographs. There's a lot of evidence here, but there's not a lot of dispute about that. There were 7 shots fired, and predictably, the police recovered 7 shell casings. They recovered 7 bullets, 2 from the car, 2 from the street, and the medical examiner recovered 3 from Mr. Suleiman's body. The medical examiner, Dr. Nunez, testified. Her opinion was the cause of death was gunshot wounds to the torso, and the manner of death was a homicide. She described the 4 gunshot wounds to the chest that were suffered by Mr. Suleiman. And this is an exhibit that has been restricted by the court in terms of public dissemination, but this is a photo of that. And she described these wounds in sort of clockwise fashion in her testimony. We got the medical records and evidence from both Trooper North and Mr. Suleiman. They are exhibits, 38 and 39. And they'll be in there in the jury room with you if you want to look at them. Essentially, exhibit 38 is Mubarak Suleiman's medical records. He basically arrived at the hospital dead. He had no pulse. He was declared dead at 6:03. They tried some intervention, but it was unsuccessful. Exhibit 37 are the hospital records of Trooper North, which indicated not a lot of complaint from him. They took his vital signs twice and basically sent him home. So the key evidence in this case really was the videos of the various police officers, either the dash cameras or the body cameras that they have. And I want to play some of them. But as the judge indicated, each side only has a limited amount of time here to make this argument. So it's going to be somewhat restricted what I play. But you're going to have these. You're going to have these in the jury room. We're going to provide you with a computer. You can look at them completely, however many times you want, in connection with your deliberations. And if you have any issues in terms of like the operability of the computer or anything like that, I assume you can send the note out to the judge and we'll try to address that. But I don't think you will. So what I'd like to play first is Trooper Jackson's MBR from exit 43 through to the completion of the shots. Please stop it. Could you also now go to Trooper North's body worn camera, pretty much in the same spot from the exit 43 through the firing of the shots? And then Trooper Jackson's body worn camera. BWC 2. Please. And then Trooper Darling's NBR. Okay, thank you. You saw these, you can see them again. It's apparent that just before the shots are fired, all the police officers are outside the car. No one's going into the car. You can see that clear as a bell. That only 35 seconds elapsed from the time that the Hyundai came to a stop until the shots are fired. 35 seconds, that was it. You had we heard some expert witnesses in this case, but the issue here, folks, is whether Officer Rappa was in mortal danger, justifying the use of force, deadly force by Trooper North. And in no time was he in mortal danger. That's a decision you can make. I don't think you really need expert testimony to help you on that, but we heard from some experts. None of them were there at the time of the crime. None of them they gave you the benefit of their expertise. Dr. Porcher this morning talked about his disagreement with some of the defense experts in the sense that pause was possible. They could have sort of slowed things down, called a supervisor, and maybe a supervisor who would not have been amped up by this pursuit would have had a more measured approach to this whole situation. He talked about one-shot drill, that each shot Each shot a police officer takes has to be justified. It's not like you turn the switch and fire a gun as many times as you can. It doesn't work like that. And he's testified that the light from that flashlight, now he didn't get a lot of detail about this, but the light from that flashlight affixed to the police officer's gun would have illuminated the passenger compartment of the car there. The defense experts and the defense and the state police witnesses that testified, they completely dismissed the idea that taking a pause, doing some de-escalation was feasible in this situation. It's too quick. You can't do it. There's no time. It was not possible. Can't do that in a real life situation. You can't do that in a real life situation. Because if the alternative is you're trying to get a better outcome here. You're trying to get a safe outcome here. Get a sergeant there. Follow the state police policy, which says, look, on these pursuits, it may affect you. Be careful with using force. That's why they have these sergeants involved in these things, to sort of take a more measured approach to these incidents. The defendant testified. His main claim is that he fired his gun 7 times at Mubarak Suleiman because he thought Rapa was entering the Hyundai through the passenger side window and in danger of a knife attack. That's the gist of his claim. He admits he had tunnel vision. He admits there was no plan. He says Suleiman said nothing during this whole situation. May not even heard Jackson's command to get out of the car. The taser was basically irrelevant. And as we heard from the technical stuff from Paul Taylor, the decision to fire the gun occurred before the taser was deployed in this case. He testified he had no recollection of his oral statement on the scene to Trooper Richter. He had minimal recollection of his statement to Sergeant Kylan. He acknowledged that each pull of the trigger has to be justified. And he acknowledged that if you fire just one shot, okay, just one, maybe, just maybe, the trauma surgeons at Yale Hospital could have saved this young man. Maybe. He acknowledged that. He acknowledged that the first shot was fired when the knife was pointed toward his window, not toward the passenger side. And let's see. He indicated. Let me see. I asked him a question about objective reasonableness, and I asked him a question and said, "Look, if that West Haven officer or anybody else was not entering the car, it would be objectively unreasonable to shoot and kill the driver." And he said, correct. So if no one's getting into that car, it's objectively unreasonable to shoot and kill the driver because he posed no threat to anybody. And that's exactly what happened here. No one's going into the car. As we'll talk about later, it was unreasonable to think anyone was going into the car. So what do we have here? We've got a 19-year-old young man who did not pose any imminent threat to or serious injury to anybody. Look, this is not a hostage situation. This is not some situation where the police have to run in at all costs at breakneck speed to save somebody's life. It was not that. The window shattered. The glass shards come into the passenger compartment of the car. He comes to. The young man's probably confused, probably afraid, and he takes a knife out of his pocket and sticks it up in the air, and no one's entering the car. It was unreasonable to think anybody would enter the car under those circumstances. The defendant fired 7 shots in 1.4 something seconds, 7 shots. Right to the chest, killing Mubarak Suleiman. I submit to you folks, that's manslaughter. That's extreme indifference to human life, recklessly taking the life of somebody else with a gun. That's what it is. And so it's not justified. There's no credible evidence at all that's produced in this trial that anybody was in imminent danger at that moment when the knife is stuck up in the air. So I'm going to ask you to return a verdict of guilty as charged on manslaughter 1. Thank you very much.
Good afternoon. Pardon me as I reach for a computer here. Hopefully it works. Thank you for your time. I really, obviously, I appreciate it. The state appreciates it. We all thoroughly thank you for that. Now, just give me 1 sec. So this is my only opportunity to speak to you. The state, by design, has the ability to go first and last. So it's my only opportunity to speak about what the evidence is. And they have that advantage. They even get to sit closer to you than I. And it's all done by design. Now, the questions are, what is your job? Well, your job is to determine whether the state proved this case beyond a reasonable doubt. So let's talk about the burden of proof for a minute. Because it's the burden of proof that is so key to this. Proof beyond a reasonable doubt. Well, what does that mean? You're going to be told what it means. But I'm going to tell you what it's not. It's not, is it possible that he broke the law? Is it probable that he broke the law? Maybe, possibly, could be. That's not proof beyond a reasonable doubt. Reasonable doubt is something that's going to keep you up at night. The decision you make, is it going to keep you up at night? Reasonable doubt is saying to yourself, I could be wrong. It's possible. He may have done it. That's not enough. He could have done it. It's not enough. And under the law, one single reasonable doubt's enough. That's all you need. The state can't prove its case, and there's one reasonable doubt in your mind, and that is simply enough. So you can't speculate. So that being said, let's move to the facts. And again, I'm not going to rehash the facts. We've all been here for 8 days. But conspicuous by its absence in the state's presentation was its analysis of evidence starting at exit 43. That's not the facts of the case, is it? The analysis of the case is Norwalk. You need to know that. This jury needs to know that. And this jury needs to know, what did Trooper North know? And you got to start in Norwalk, because Norwalk is where this all began. Norwalk is where they told, via the Troop G dispatch, carjacking with a knife. Whether that was right or wrong, that's what they said. That's what was conveyed. That's what the troopers knew. So the troopers were told about carjacking with a knife. The troopers were told about the speed on the highways. The troopers saw the speed on the highways, the way he was driving, the speed he was driving, the manner he was driving. Trooper North and Trooper Jackson tried to stop him at the 36, 37 area, unsuccessful. Tried to box him in, unsuccessful. Driving like a bat out of hell, the video shows that. This is the information that the trooper had. So it's not what happened underneath the overpass. It's relevant, but what happened starting at 27, because the analysis is what he did in his mind reasonable, and objectively is it reasonable. Now, Mr. Suleiman may very well have been mentally ill. Fact of the matter is, troopers didn't know that. So that may be, in fact, the case, but what did the troopers know? So the facts are, from Norwalk to West Haven, the car stopping in West Haven, the Hyundai Sonata, because Mr. Suleiman hits the civilian vehicle. The incident that we'll talk about soon. Those are the facts. The facts also are, after the firing of the weapon took place, that Mr. Suleiman was removed from the vehicle, where officers, including Trooper North, provided CPR and assistance and first aid to Mr. Suleiman. So when Attorney Devlin says no threat was posed, well, of course he posed a threat. Because again, it's not just, do we have an unconscious guy in a car? Is that threatening behavior? It's, what has he done since 27? Using his car as a deadly weapon from 27 to 43. And actually not from 27, when I say 27, I mean exit 27. He was driving from Route 7 in Norwalk, that's exit 16 on 95, from exit 16 to 43, like a bat out of hell. Using that car like a weapon. Driving, breaking every possible rule of the road. Getting off the highway, going around people, hitting a civilian. Lord knows where he would have gone had he not hit that civilian. Did he pose a threat? Absolutely, because he was not compliant at any point in time. I asked all of the experts about that. There was never at one point in time any show of compliance at all. So let's talk about the charges for a minute. I'm not going to spend a bunch of time on the charges, but I think obviously they're important. Manslaughter first with a firearm, manslaughter, and then there's these lesser included offenses, which I know the judge will tell you about. Manslaughter second with a firearm, and criminal negligence. I submit to you that before we even get to the defense of others and justification, there's no evidence to prove beyond a reasonable doubt recklessness. The state says, well, 7 shots equals recklessness. The law provides, and I look down occasionally just to make sure I get it right, a person acts recklessly when he is aware of and consciously disregards a substantial and unjustifiable risk. Extreme indifference to human life, which is part of the statute, is more than ordinary indifference. It's synonymous with excessive and is the greatest departure from the ordinary. Being a police officer is a really difficult job. I asked all of you during voir dire whether you agreed with me. The police officer's job is very difficult. Split-second decisions are made, and these decisions are made with the information they had at the time and with the conditions they had at the time. How did Trooper North act recklessly with an extreme indifference to human life, with indifference which is the greatest departure from the ordinary, in doing his job? He was properly trained, as you've heard testimony about training. He was a tactical officer, so he received in the last quarter of 2019 alone 100 hours or many, many hours of training to make him proficient with the use of a weapon. His training was also presented here, because not only did Trooper North talk about his training, the actual training officer came in and testified about the training that he and other members of tactical underwent. So the state wants you to believe that he's being reckless for simply doing his job. You heard arguments about felony car stop, that this wasn't a felony car stop, it violates policy. Well, again, we know about policy, do we not? Every single officer was asked about policy. Policy is just a policy. It's not black letter law. It's only to be followed when feasible. So if felony car stop policy was followed, then the gentleman in the Trailblazer could have been shot and killed. Felony car stops are when the car stops on its own, when the driver's compliant. That didn't happen here. A felony car stop is when the driver puts his hands up and submits to authority. That didn't happen here. So there's no evidence of recklessness. There's no extreme indifference to human life, because he was working as a police officer, doing a difficult job, following the training that he received. Now, every circumstance is different, right? Every every situation is unique. Split-second decisions. The lesser included offenses also continue to talk about recklessness. Again, I submit to you, recklessness has not been proven. The final lesser included offense you're going to hear about is called negligent homicide, where it says a person is guilty if they act with criminal negligence. And that is defined as when a person fails to perceive a substantial and unjustifiable risk. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care. Again, if you're following your training and your experience, making split-second decisions within a minute's time, how is that negligent? How is it reckless? How is it negligent? You know, the crucial point is this. We've spent 8 days talking about an incident that the crucial part of it only took 35 seconds. When Trooper North and Trooper Jackson and the others were at that scene, they couldn't slow time down. They lived it in real time. They weren't observing it in half time or quarter time. They weren't observing it in 30 frames per second. They weren't observing it through fancy lenses and filters. They couldn't stop it. They couldn't stop time. We all live in real time. But we just spent 8 days talking about something that took 35 seconds, which is what we have to do. But my point is, what was in Trooper North's mind at the time, and was it reasonable? You can't hit stop to make sure that as every movement happens, it's correct. Hindsight is not, well, what do you hear? Hindsight's 20/20. I asked, I think it was one of the sergeants, about hindsight being 20/20 and Monday morning quarterbacking. That's what this is. We're taking an event that happened in real time, and we're being asked, everyone's being asked to critique what should have happened, what could have happened, what maybe should have been the result. That's not what this is about. This is about what happened and what did Trooper North know. So now let's move on. If the state proves its case beyond a reasonable doubt, that is to say, if they prove the elements of those offenses or one of the offenses beyond a reasonable doubt, you'll be told how the lesser includeds work. Then it shifts to the defense. Defense, again, is defense of others. And simply put, Trooper North was defending Trooper Jackson and Officer Rappa. So what is the analysis that you have to undergo? It may sound complicated, but it's pretty darn simple. Did Trooper North actually believe that Mr. Suleiman was imminently about to use force? And was that reasonable in his mind, and objectively was it reasonable? And did Trooper North believe it was necessary to use deadly force? So did Trooper North actually believe Mr. Suleiman was about to use force? And was that use of force necessary? And the jury instructions are going to say it pretty clear. But let me just point out a couple things. What did Trooper North actually believe? Well, you can take that right from his testimony. He testified clearly and succinctly, I would submit, as to why he fired his gun. In fact, I quote, "Please describe again why you fired your weapon." From the transcript, it was to protect the West Haven officer and Trooper Jackson from the threat of imminent death or serious physical injury. So from the subjective point of view, from Trooper North's point of view, what did he think? That was what he thought. And what he thought is not just what happened under that overpass. It's everything that happened from Norwalk forward that he was providing. So that's subjective reasonableness. What did he think? Did he think that Mr. Suleiman was about to use force? He testified about the movements in the car and that he believed through an open window there was a clear path between Mr. Suleiman and Trooper Jackson and Officer Rappa. 5 feet, I think, was the distance, the wingspan. There was a clear path. That's subjectively reasonable. It was Mr. Suleiman that there were two people that changed sort of the narrative in this case. One is West Haven for breaking the window, because who knew that was going to happen, but it did. And then Mr. Suleiman changed the narrative. Because Mr. Suleiman, had he stayed unconscious or pretending to be unconscious, that's one thing. This would have been handled completely differently, but that's not what happened. In this increasingly changing landscape with the window breaking, there had to be this reassessment. So let's talk about objective reasonableness. So subjectively, he believed Mr. Suleiman was about to use that weapon. Is that objectively reasonable? Is that reasonable for a person, a reasonable police officer in his situation? Well, a reasonable police officer in his situation would know about everything that Mr. Suleiman did from Norwalk through West Haven. So that's undisputed. They had to know that because of that's, you're being asked, would a reasonable police officer in his situation have done this? Now, is it objectively reasonable? Well, Trooper Jackson and Officer Rappa both said, we were in fear for our lives, and we were in fear of death or serious physical injury. The troopers themselves, the officers themselves said that. So if the officers who were quite possibly going to be those victims of this potential knife attack, if they felt as though they were in fear of death or serious physical injury, how is it not reasonable to think that the Trooper North felt that way as well? Now, granted, it's a different perspective, right? It's the perspective of the right side of the car where Trooper Jackson and Officer Rapp are, and Officer North's side of the car. But if the officers on the right side of the car themselves said they feared death or serious physical injury, why is it not reasonable to think that Trooper North could have felt the same? You have to analyze it again from the circumstance of what he knew and what did he bring to the scene. So let's move on then to the second analysis, right? So first analysis is did Trooper North believe that Mr. Suleiman was imminently about to use force? And actually, one more point on that. The state shows these segments of a video where literally at the moment where the shots are fired, it appears Mr. Suleiman was possessing his knife on the right-hand side, facing the left-hand side of the car. But please watch Trooper Jackson's body-worn camera. We just watched it. And what does it show? After the window was broken, Mr. Suleiman looked to his right side, turned to his right side, and moved towards his right side. The second analysis, whether Mr. Trooper North believed it was necessary to use deadly force. Part of the jury instruction is going to say that this applies, or rather the question is whether the defendant believed that it was necessary to use that degree of force that he used. Once again, did he feel as though deadly force was necessary? A knife was being possessed by Mr. Suleiman. He pulled it out of his jacket with his right hand, and he was turning to the right. Ultimately, you see him turn to the left, but the video clearly shows he turning to the right through a window that was open because it was broken with a clear path, a clear, unobstructed path within the wingspan of those officers. And the officers themselves said, I was in fear of death or serious physical injury. Trooper North even testified the same. That Rappa or Jackson would be stabbed in the face or neck. This idea of a tactical pause is confusing to me because when and how was this tactical pause going to happen? When was it going to happen? Had he stayed unconscious? Sure, this is a whole different case because he is not moving. He's not showing any signs of threatening behavior, even though he was just showing violent threatening behavior from Norwalk to West Haven. But if he's unconscious, maybe tactical pause works. But there was no chance because West Haven breaks the window. He comes too. Mr. Suleiman comes too. In fact, actually, Mr. Borden, who testified yesterday, said there was a tactical pause, if you think about it, because by positioning themselves where they were while he was unconscious, that was a tactical pause. But it was West Haven, again, that stirred this pot and got Mr. Suleiman moving. Don't go down this rabbit hole, by the way, of somehow Trooper North is somehow guilty of some offense because there was no supervisor there. Connecticut State Police is not on trial. Policing is not on trial. Societal thoughts or values about police are not on trial. Trooper North is on trial. When would there have been time for a supervisor to be there? When Mr. Suleiman was turning, holding a knife with an open window, are you going to tell Mr. Suleiman, let's stop, hold on, got to get my boss here? We know that's not possible. And in fact, Sergeant Swickler was there. He's a superior to these other officers. So technically, he was on scene. He didn't stop anything. Nobody stopped a pursuit. Nobody stopped Sergeant Swickler or any other superior. Stopped nothing from happening that day. Tactical pause, completely unnecessary. De-escalation, not doable. Again, how can you de-escalate this situation when West Haven's breaking the window and now the story has changed, the circumstances have changed. You can't de-escalate now that a man has got a knife and moving from side to side, and you would think planning on using it. I don't mean to cast aspersions to Mr. Suleiman, but he made a series of very bad decisions starting in Norwalk. From what he did in the AT&T store, to the Lyft driver, to the thousands of motorists on 95, we saw how he was driving. So you can sort of assume if there wasn't any compliance from Mr. Suleiman starting in Norwalk to West Haven, are you going to start getting it now? Now's the time he's going to start complying? This is what the reasonable officer thinks about. This is what Trooper North thinks about. This is what the analysis is, not what ifs, not, well, maybe this should have happened, maybe that could have happened. No. What happened in Norwalk, Mr. Suleiman stealing this poor guy's car, smirking as he drives away. This is the person the police are dealing with. So getting back to this reasonableness analysis, whether, again, to be clear, whether he thought that Mr. Suleiman was imminently about to use force, was that reasonable? And whether he believed it was necessary to use deadly force to defend others, and whether that was reasonable. How does this objective reasonableness happen? Like, how you say, well, okay, we know what Trooper North's position was through his testimony. How are we supposed to analyze what an objectively reasonable police officer would have done? And does that line up with what Trooper North did? Well, you determine objective reasonableness by determining what he knew. You consider the fact that a reasonable officer like Trooper North was proficiently trained by the Connecticut State Police. He received tactical training with the use of a weapon over 100 hours. The use of a gun obviously is very relevant in this case, because the question everybody asks themselves in this case is, why 7 shots? And the answer is, as Trooper North testified, 7 shots because that's how I was trained. 7 shots because it was one brief engagement. I shoot until the threat is over. There's this testimony about 1-shot drills and 2-shot drills. Well, Trooper First Class Bresniak came and testified and talked about the actual training that these troopers undergo, especially in tactical. And I know Mr. Porcher has used a gun, but he testified he was never a trainer when it comes to weapons. But Trooper First Class Bresniak was. And he says, we do up to 10-shot drills. The reasonable police officer, like Trooper North, engages in one brief engagement and engages until the threat is over. That gun, that clip in that gun was not emptied out. Some may say, well, he probably was negligent or reckless in using the gun. He fired until the thing was empty. You saw pictures of the gun. You saw pictures of the clip. There were 10 bullets still left, 10 plus 1 in the chamber still left in that gun. He didn't empty that gun out. He fired that gun until that one brief engagement ended and the threat was over. That clip was not emptied out. Would a reasonable police officer have done that? Shot until the engagement was over. It would be a different story, I suppose, if that clip was emptied, but it wasn't. What would a reasonable police officer do in this situation? Well, Many police officers testified in this case, and every single one of them, and it's your recollection that controls, but every single one of them said, and I'm summarizing, this couldn't have been done any differently. And I asked Trooper Dalling, and I asked Trooper Jackson and Rappa, and I asked all the officers, even the officers who weren't even at the scene, and I asked about procedure and policy. And that one police officer said that anything different could have happened. There couldn't have been, a tactical pause. There couldn't have been de-escalation given what the scene provided and given what the police were told. Paul Taylor and James Borden provided assistance in that reasonableness analysis. And they provided what I submit as very useful information about, for example, perception response times, and that when something happens, you don't act immediately, you act hundredths of a second or within a short period of time, but it takes time to essentially see something happen and then act on that. He agreed that Trooper North fired in response to Mr. Suleiman turning towards him in the window. He said that was supported by perception response and all the evidence that he had. He concluded that the positioning around the cars was not a felony. Both said it's not a felony car stop situation. Because again, felony car stop, and you saw it on the picture, that is a traditional felony car stop. This was the complete opposite of what that is. The complete opposite. Had it been that way, this would have ended differently. Mr. Borden stated that in this analysis of use of force, because this is a use of force case, right? So Mr. Borden was asked, well, what is the decision-making process? What does a police officer, right? We're trying to figure out what does a reasonable police officer do in these circumstances? What should a reasonable police officer do? And he talked about this case, Graham versus Connor. He stated that there's a three-part process. You analyze the severity of the crime. Was the individual an imminent threat? And was there continued resistance or an attempt to avoid arrest? And again, without going painstakingly through the evidence again, the severity of the crime was that this thing started as a carjacking, or so they were told. And the police knew about how Mr. Suleiman was acting from Norwalk through West Haven, committing many crimes along the way. Was the individual an imminent threat? Not only was he a threat because he was driving a car, which is a deadly weapon, the way in certain ways that it's used, but he had a knife. And he, after coming to, pulled it out immediately. And was there resistance or attempt to avoid arrest? The state's theory is, well, he was sitting in a car. How is he resisting? Mr. Suleiman showed not one iota of compliance that entire afternoon. From Norwalk to West Haven. So why would you think he would start then? Remember, Trooper North was actually concerned about Mr. Suleiman after the collision with the Trailblazer, but before the firing took place, because it was a low impact collision. It wasn't so high impact that it would have, made the driver unconscious. And I asked questions about, well, how is it high impact, or words to that effect? Window wasn't broken, airbag wasn't deployed, car was still operable. We knew the car moved after the fact. So he never showed compliance from moment one. So in the analysis of was there continued resistance or an attempt to avoid arrest, he drove from Norwalk to West Haven without stopping. There were attempts to stop him, it didn't work. There were attempts to box him, and it didn't work. So yes, there was resistance. Trooper North also testified too that when it comes to firing a weapon against someone who's in a seated position versus someone who's in a standing position, that's very relevant. Because when someone's standing, they react by falling. Person who's seated you don't know, you can't tell the way the body will react. Also, too, when the Attorney Devlin speaks about this one shot reassess or one shot, is each of them is a deadly threat. We heard from Trooper North and Trooper First Class Bresniak that those first shots very likely, and it's your recollection of the evidence, very likely ricocheted off the window. I asked Trooper Bresniak about intermediate barriers and the reaction that a bullet can have, and his response is there is a reaction. He used an example of throwing a baseball to another person and there's glass in the way. So those beginning shots, I would submit, ricocheted. There was evidence that bullet projectiles were actually outside of the car. All of these tools, many of these tools that you heard in this case were based upon the idea of hindsight. Again, this is not a hindsight case. For this defense to work, again, the state has to prove their case if they can, and then disprove beyond a reasonable doubt these elements. Now, that sounds confusing. They have to prove that these didn't exist beyond a reasonable doubt. So much like you have to be convinced with very confident certainty, or with a high degree of confidence that they prove their case, you also have to be convinced with that highest degree of confidence that one of these things, one of these four elements doesn't exist. And I would submit to you that when you look at this subjectively and objectively, it's clear. It's clear that Trooper North used this force, that and again, to make sure that you understand, that he believed that he was imminently about, that Mr. Suleiman was imminently about to use force and that force was necessary. Subjectively, he testified, yes, he's imminently about to use force, and objectively, I argue, that's reasonable. It's reasonable because not only the way of his training, but the testimony of all the other officers on that scene, including the two officers who said, I could very well have suffered death or serious physical injury. And then, was it necessary to use deadly force? Sadly, what other force could have been used? With the introduction of the knife and the introduction of his actions, there's no other way. Through the training experience that he received, through his proficiency in the use of weapons, the result is what we saw on video. Also, this idea that Officer Rapper, Trooper Jackson were somehow not close enough. Watch the videos. Look at the still frames. Again, unfair to do so because this unfolded in real time, but you saw, and I brought it up through Mr. Lacey during cross, that the feet of Trooper Jackson, Officer Rapper were right in front of that door, and both of those officers were reaching for that door multiple times. When you're watching Trooper North's body-worn camera, Officer Rapper's head continuously ducks down. Don't look at a single frame and say, oh, I don't know. When you look live in real time, Trooper North's position that Officer Rappa ducked under roofline is what is displayed in the body-worn camera. This analysis has to consider the fact this was a very tense situation. The fact that Trooper North didn't give an explanation in full to Sergeant Kiley is of no moment. I asked Sergeant Kiley, was this an interview? No. Did you intend it to be an interview? No. In fact, Sergeant Kiley, moments after that happened, said, you better get to the hospital. And I asked Sergeant Kiley, why did you send him to the hospital? And he said, because I know the toll that this takes on people. And I asked him, does it take a physical toll? Yes. Does it take a mental toll? Yes. Does it take an emotional toll? Yes. Trooper North had just experienced the most and then attempted to perform first aid and CPR on Mr. Sullivan. And seconds after that, you pull him to the side and say, okay, quick synopsis, what happened? And this poor kid who's in shock, you could see it in his face, gives an explanation and immediately goes to the hospital. The state says, well, because he didn't give a full dissertation on what happened that day, that must mean that he's either, I don't know, not being truthful, not being cooperative. Wrong. He was answering the question that was asked of him. He was asked for a quick synopsis, Officer Kiley's words, and then he was brought to a hospital. And I even asked him, what impact has this had on you? Well, we know his heart rate was sky high. The hospital records show that. This keeps him up at night. Of course it does. He thinks about this every day. This is a terrible event. Someone lost their life. But the question is Trooper North criminally responsible for that? He is not. Because what he did that day, both subjectively in his own mind and objectively, what would a reasonable person do, through the testimony of the experts and the lay witnesses, both say that it was reasonable. Again, policing is not on trial here. Trooper North is on trial. And this verdict is about the reasonableness of his actions at the time, considering what he knew and the split-second decisions that he has to make. So consider what he knew at the time. This verdict is not about hindsight being 20/20. This verdict is not about Monday morning quarterbacking. It's what did he know? I'm sure that for years going forward, people are going to assess and reassess what happened here. But that's not what Trooper North had in his mind under that overpass. It's the subject's actions. In fact, I will point this out too. On multiple occasions, I showed multiple officers, including the experts, the use of force matrix, that colorful series of boxes. And after that, there was, and it's the State's 41, a list of concepts that I'm going to read a few to you now. In fact, Mr. Borden read them all out loud. Trooper North read many of them out loud, and they're very applicable to today. And this is the training experience. What does a reasonable officer do? What did Trooper North do? Their training tells them this. It is the subject's actions which dictate the quality and quantity of force used by an officer in response to threats in order to exert control. The need to exert control is in a law enforcement or custodial setting is often characterized by the rapid and unpredictable changes requiring an officer to continuously reassess a subject's action as well as his or her response to those actions. The use of force inquiry is not a focus on what the most prudent course of action may have been, but instead what the seizure actually effectuated falls within a range of conduct that we call objectively reasonable. And most importantly, there exists no legal requirement to choose the correct means of gaining control over a subject through the use of force. The appropriateness of a use of force is judged upon the reasonableness of the officer's perception. There's no right answer here, ladies and gentlemen. There's no right answer. Policy states that. What's reasonable? And the evidence shows that through Trooper North's testimony and actions and the rest of the testimony, both lay and expert, he acted reasonably. And a reasonable police officer, knowing what he knew, that was reasonable as well. Trooper North walked into this room on the first day of trial, presumed innocent, and listened for 8 days, as we all did, about the presentation of evidence and witnesses, and listened to law enforcement one after the other come here and testify that, in fact, it was Trooper Dalling who even said that there was no other way that this could have gone down the way that it did. The presumption of innocence started at the beginning of this case, and it continues to now. The state has not proven this case. I submit to you that the state can't prove the elements as charged, the elements of the offense as charged. If you find yourself going into the defense here where the state has to disprove beyond a reasonable doubt one of these four elements of subjective or objective reasonableness, they simply can't. Because witness after witness stated that it was reasonable. Brian North is not guilty of manslaughter in the first degree with a firearm and any lesser included offense. He acted reasonably. He operated through his training and his experience. He has not committed a crime. Thank you.
Mr. Devlin, rebuttal?
Yes, thank you. I'd like to retrieve a couple of exhibits. Here, we're going to kick this off here. Oh, yes. So this is my last chance to talk to you. Hope you're not too tired. I can have your attention for a few more minutes here. So we're round and third heading for home here. So we're almost done. So I want to respond to a couple of things that Attorney Riccio said, and then talk a little bit more about the case before the judge takes over and gives you his instructions. The judge is going to give you instruction on recklessness, which is disregarding a known risk. Look, if the recklessness here is shooting someone without a reasonable belief that somebody was entering the car and needed saving from death. If you don't have a reasonable belief to do that, you can't kill somebody. And shooting Mubarak 7 times, that's extreme indifference to human life. That's the recklessness. Look, Trooper Jackson, Trooper Darling, look, they are friends of Brian North's. They work with him. Jackson was a classmate of him. I'm going to submit to you folks, they're on his side in this trial. They're not on my side. None of the cops are on my side. And none of the police, the experts that have police backgrounds, they're not on my side here. That's their bias is the other direction, which is okay. You just have to sort of know that. This idea of a pause, Attorney Riccio's right. The Connecticut State Police are not on trial here. And I've never suggested that they are on trial here. But as Dr. Porcher said, look, all somebody had to say, he said, oh, time out. Let's get a boss here, okay? This is a serious situation. Time out. Let's get a boss here so we can sort of make this thing go in a sort of reasonable way. Nobody did that. And that was a mistake. That was a mistake. The law here is not what some court case that one of the defense experts talks about. The law here is actually pretty simple to state. You can't kill somebody unless they're posing a lethal threat to somebody else. And you can't do that. That's against the law to do that. And I submit that's what happened here. And I didn't know, and I know Attorney Riccio didn't mention, but no expert testified that Trooper North's conduct was reasonable. In fact, if someone tried to testify that, the judge would not have allowed that to come into evidence because that's your decision. That's nobody else's decision. That's your decision whether or not his actions were reasonable or not. And I would say that reaching for a window, and there's evidence that these people are reaching for a window on the passenger side of the car, that's different than climbing through a window. Completely different. One thing is try this test a lock, or test a handle to see if the door will open. It's different there. It's a different situation entirely. And Jim Ricker's kind of blended into it. There's this notion, kind of in the shadows of this case, that somehow because of misdeeds in Norwalk or on Interstate 95, that Mubarak Suleiman forfeited the protection of the law at Campbell Avenue. That's not true. And that's a disturbing assertion. It's not asserted directly, but it's kind of weaving a thread that weaves through this case. That's not true. We have a court system that could deal with misconduct fairly. And it would deal with whatever misconduct was involved in this case. But that's irrelevant to what happened on Campbell Avenue. That's irrelevant. And the thing is, this court system never got a chance to work because this defendant shot and killed Mubarak Suleiman. So 35 seconds. That's how long he lived after the car stopped. And really, what could have caused that? 35 seconds. I have my phone. I was going to measure out 35 seconds. But you know how short 35 seconds is. And it's nothing. What caused it was Brian Norris' extreme indifference to human life. And in this case, folks, I got to tell you, we've had too many excuses, too many rationalizations. This young man is dead and he shouldn't be dead. That's the bottom line here. These state police guidelines are guidelines. They are not black letter law. And I acknowledge that. But they are thoughtful and useful. And there's wisdom in them. So this is Exhibit 42. It says under arrest considerations, because of the high level of emotions generated during pursuits, troopers and police officers must be aware that any physical force used to apprehend a violator must be reasonable and consistent with both state laws and department policy regarding the use of force. Now, why do they say that? Because they know that troopers are amped up after these pursuits and might make bad judgments. That's why they say, slow it down. Be mindful of this. And we're dealing here, folks, with a chaotic environment. Let's face it. There's noise. There's sirens. There's cars running over Interstate 95. There's flashing lights. There's just smashing of a window. There's no plan. There's no communication. Nobody's in charge. Chaotic, okay? But North is the only one that fired his gun. North is the only one that took another person's life. He's the one responsible for that. And so it's not like the police department's on trial here or these other mistakes that they made, which were plentiful, somehow excuse him from his own criminal conduct. It shouldn't. And all these things I just talked about were under police control. North saw the knife and he fired. This whole case, this entire case can be sort of summed up in that one statement. North saw the knife and he fired. So how do we know that? Well, look at the videos. Could you cue up Jackson's body worn camera, at 1.13? Actually, excuse me. Let's go to Dolling's MBR at 112. That's it. So, here's Trooper North. Here's Trooper Jackson. Actually, go just maybe one more frame. Ahead or back. Either way. Okay. Here's Jackson. He's aiming his taser. Here's Rappy. He's near the car. Here's North over here. Here's Sergeant Zwickler. Nobody's entered that car. Nobody's in danger of something that this person might hold here. Nobody is. Here's Jackson. So if you look at the video, he fired because he saw the knife. And even when Suleiman held the knife up, He didn't pose any risk of serious injury or death to anybody outside that car. Let's take a look at what Trooper North said to Sergeant Kiley. That's another reason why, you know, he saw the knife and he fired, because that's what he told Kiley. So let's play Sergeant Hennessy's body on camera, please. The first one.
How's it going? You got it. Everybody okay?
You want to give me a quick synopsis of what happens when the bosses are asking? Just that
Stop again. You want to give me a quick synopsis so when the bosses start asking. So when the bosses start asking. This is a white trooper that has just shot and probably killed a young black man. Okay, this is a big, big, big deal. Okay, the bosses are going to want to know. This is Moore's golden opportunity to say, look, hey, I shot because I thought a cop was in danger. I thought I was saving life from a police officer. That's why I did. That's the only reason I did it. I'd never do something like that without that happening. So continue playing it.
No, I mean, I saw most of the video stuff on the island. You saw like the DA. Yeah. The guy here, basically, I guess Jackson from me. Kind of like got boxing behind the other part. That was just in the red lane. Then Jackson kind of pulled up here. And I went around the front. We get out, finally stop by the driver's side door. Jackson's on the end of the door, pulled out, comes out. The guy's kind of like out of it. He was passed out. And West Haven guy here did go to the passenger side window. And when I didn't.
So we don't hear the rest because I would submit to you, North gives the evil eye to Hennessy to shut off his audio. But we have it because the sergeant wrote a police report that summarized what Trooper North said. And he said this. I asked Trooper North to give me a quick synopsis of what happened. Trooper North explained that after the suspect crashed into another vehicle, he and Trooper Jackson positioned their cruisers to box the suspect in. Trooper North explains that he approached the driver's side of the suspect vehicle while Trooper Jackson approached the passenger side. Trooper North further explained that he was utilizing felony stop procedures at this point. He explained that the suspect initially appeared to be out of it, but when the West Haven police officer shattered the passenger side window, the suspect was startled and came to. Trooper North stated that the suspect then reached into his waistband and pulled out a knife. Trooper North stated that he subsequently fired his duty weapon. North stated that the suspect reached into his waistband and pulled out a knife, and that he subsequently fired his duty weapon. He saw the knife and he fired. He jumped the gun. He saw the knife and he fired. Can you please play Exhibit 47, Trooper North's body worn camera number 2 with the involving Officer Richter.
We started doing a phone stop. He was like unconscious, it looked like. And then he came to when they broke the window. Yeah. And then the first thing he did, reached in his pocket, pulled out a knife. And that's when I started.
Can you stop it? So it's faint at the end, but if you really listen to it carefully, the last couple of words was, and then I shot him. Aside from that, again, this is a fellow trooper that he's giving this account to. And again, he mentions nothing about somebody going into the car. Not a word of that. Okay, the guy reached in his pocket to pull out a knife, and that's when I fired. He saw the knife and he fired. Take a look at Trooper Jackson's what Jackson says at the scene when the sergeants are talking to him. Look at body on camera 2. Hennessy, body on camera 2. Sorry.
And he kind of came up behind him, so I boxed him in that car on the sidewalk. And then you just kind of sit there and goes, where's your car? This way. I got out this side, you just kind of, square up in space time and not doing anything. I'm on the passenger side. I had to draw someone to get out of the car and I'm not doing anything. And North got out and, basically this, he had me draw less details like taser.
He told you to have a taser ready?
Yeah, I actually woke up legal cover, so when I switched left legal cover, I got legal cover. And then the same thing grabbed my baton, broke the window. He wasn't coming out, he had a knife in his hand. I deployed the taser and fired his gun.
That's it. Again, he had a knife. I deployed my taser. North fired his weapon. Nothing about people going near the car, going anywhere near the car. Hey, North might have thought we were going to the car. No, nothing about that. So let's look at what North did not say. So this is what he said, Kylie to Richter. What did he not say? Right after this happened, if in fact he made this total blunder that he thought people were going into the car and they weren't, wouldn't he say something like, wait a minute, I thought you guys were going into the car. You guys okay? He says nothing about that. Not a word about that. You know why? Because he never thought they were going into the car in the first place. He never did. Let's look at these enhanced slides. And I know Trooper Rick is right that, you don't see with the human eye at this level, but these things are useful to try to understand the chronology of these things. So this is, and you'll have these in the jury room. You can look at them if you want to. And this is this slide-by-slide presentation. This is 57A, exhibit 57A in our trial. And you can see that this is the first slide. Okay, the first slide of the series where you see this object, which is the parties have identified as the knife, as this kitchen knife that Suleiman had. And the Mr. Lacey said that these slides, frame by frame by frame, are 1/30th of a second apart. So each frame, 1/30th of a second is elapsed from frame to frame. Mr. Taylor, the defense expert, said in this study that he did, where officers are given a green light prompt and told to shoot, when they see the green light prompt, the quickest officers shoot about 1.031 seconds between the light shining out and the prompt. So between, next slide, please. The knife is, this is North's first shot. So between the knife being displayed and the first shot is 1/30th of a second. 1/30th of a second. These may be the most important exhibits in this trial because within 1/30th of a second, the minimum time you have to say, this is a knife, I got to fire the gun, he fires. He saw the knife and he fired. It wasn't anything about people going through the passenger side window. It wasn't anything about the taser. He saw the knife and he fired. And he wasn't justified in doing that. So we heard what North said at the scene. So fast forward a month. And a month later, he and his attorneys and union representative, they go and they spend 2 hours looking at all this video evidence. And what comes out of that is his statement that he testified to, that he fired to save Rapper's life because he was climbing through the window. And I submit to you that came out because what actually happened, what he told Kylie, what he told Richter, that's not going to cut it because he's not in any danger. He's standing outside a locked car with the window up, and this kid's got a kitchen knife of no danger to North. So I submit to you that the testimony that he gave and his statement, you should reject that. One reason is what I just said before. He never said that at the scene, and folks, he would have. He would have. If you've got a basically gold-plated reason why you fired your gun, you're saving another cop's life, you're going to say that. Human nature, you're going to say that. You're going to say that even if they don't ask you about it, you're going to say that. To anybody that asks. The videos that we showed, no one's climbing in that car. Not even close. They're standing outside. Nobody's climbing into that car. Because it would be completely unreasonable and idiotic to do that. First off, Jackson's just about to put electrically charged taser wires into that car. Rapper's going to jump in and go in the car when taser wires are coming pretty much simultaneously. Two officers are yelling, he's reaching, he's moving, something like that. And these alerts that something's wrong cause you to pause. You would pause if you heard something like that. And as Sergeant Zwickler said, it's just too darn dangerous to do something like that. North had tunnel vision. That's another reason to reject this idea. So this notion of he has tunnel vision, but nevertheless he can see heads bobbing up and down on the other side of the car, and therefore draw this conclusion that he claims that he drew. And let's just play Exhibit 47, Jackson's motor vehicle recorder, but just at the point from where North is touching his taser on the side. So we played this during the trial. Okay. From this point forward, please look. When I understand Trooper North couldn't identify a spot when he looked over the roof of the car because it's not there. And he claimed that I played it too fast in court. They could have played it for you on redirect examination 100 times. And folks, you can play it 100 times in the jury room. He doesn't look over. He never looks over because he's got tunnel vision, which is completely understandable in this situation. He had tunnel vision on Suleiman and focused on Suleiman. And when he displayed the knife 1/30th of a second later, he fired 7 shots into him. That's what happened. He could have just looked. Look. If, in fact, he's worried about somebody coming into the car and he's got this flashlight, and Porcher testified, I know there was some objection to the testimony here, but Porcher testified that that light from that flashlight, gun flashlight, would have illuminated the passenger compartment of the car. He could have seen if somebody was coming in there. The lady down the street, who was Longley, who's sitting in her car, she can see inside that car. The officers on the other side of the passenger side could see the driver's side. It wasn't like dark in that car. You could just glance over for a split second and either confirm or dispel, if that's what he felt, that somebody was coming into the car. And North's much closer than Miss Langley and Sergeant Zwickler, who made these observations. I submit to you that Mubarak Suleiman's death is due directly to Trooper North's recklessness and extreme indifference to human life. He jumped the gun. He decided to fire even before the taser was deployed. And that's the expert, Mr. Taylor said that. Now, he fired 7 times. Each use of each time you pull that trigger and discharge a bullet from that gun is a use of deadly force. And I know that they've focused on this matrix. Let's see. Devin, do you have that? The matrix, colorful exhibit. Back of 41. Oh, I've got it. I've got it. Thank you. This matrix has this circular thing in the lower left-hand corner, okay? And it says, select the action. So you perceive what's going on, you select the action. And then you then a reasonable response to that action, and then you reassess. So you select what you're going to do, you make a reasonable response, you identify the threat, you make a reasonable response, and then it's this idea of constant reassessment. Each shot is a separate use of deadly force. Each shot has to be reassessed. It didn't happen here. He's pulling the trigger as fast as he can, 1.47 seconds to pull off 7 rounds. That's not this. That's not reassessing after every use of deadly force. During jury selection, we asked each of you whether you felt that people should be held responsible or accountable for their actions. including police officers. And you all said yes, that people should be held accountable, even police officers. Well, folks, now's the time that really counts. Look, I take no pleasure in prosecuting a state police officer. And I'm sure you take no pleasure in passing judgment in this case. You know, that's what I call a jury duty. It is a duty, and it's a grim duty. But here's the path forward. You just follow your oath, okay? Just follow your oath. And your oath was you're going to decide this case based on the evidence and the law without favor for or against anybody else, just the evidence and the law. Look, when you boil it down, within 35 seconds, okay, this Hyundai stopping, Mubarak is dead. Why? Why is he dead? Because he stuck a stupid knife up in front of his face, and Brian North jumped the gun and shot him 7 times. He's a scared kid doing a stupid thing, and he should still be alive today. What happened there at that car, he saw the knife, he fired, he wasn't justified. That's manslaughter. That's reckless manslaughter. So I would say this, folks. Justice is justice. Justice is justice. And as I said before when I started my first argument, first remarks, you know, these cases, these individual cases, they resonate through the entirety of the law. They do. They resonate through the entirety of the law. It's important that you follow your oath and decide this case just on the evidence and the law that you've heard. So I submit to you folks a guilty verdict is clearly required in this case. And so on behalf of the citizens of the state of Connecticut, I respectfully ask you to return a verdict of guilty. Thank you very much.
So that completes the attorney's arguments, both sides. The next step in the process is going to be for you, finally, to talk about this together. But first, you're going to have an abbreviated, somewhat abbreviated lunch. Is that acceptable to you? Like 45 minutes? Yes, sir. Does that work for everybody? Okay, then we're gonna break now until just after 10 after 2. And in the meantime, I still don't want you to talk among yourselves yet. I haven't given you the case. Don't make up your mind about anything. Don't discuss it with anybody, including among yourselves at all. Don't seek out any information. Don't do any investigation. You're almost there. Don't answer any press queries. Don't watch or listen to any coverage of this case or this proceeding or of the matters behind it, what you've been hearing about for the past week or so. If anything, if you are approached or if someone bothers you, anything like that over the next period, you need to let me know in writing. That said, have a pleasant lunch, and we'll see you back here at 10 after 2. So by the time we come back together, will you guys be able to go through the exhibits to your
As long as the
satisfaction?
clerk is available, Your Honor, we will be available, but
Okay. Any objections to argument?
not by the state.
Okay, thank you. So 10 after 2, we'll resume. We'll recess.
All rise.